Pleasure of introducing our keynote speaker this evening, who is a very talented, gifted, witty gentleman who has been involved in Alabama State Supreme Court for about 2 decades now, been through multiple battles. One of my friends and heroes in Alabama, when I first met Ben, I think it was during the whole Ten Commandments controversy at Alabama. There was this huge rally. There were thousands of people in the streets of Alabama. We had Alan Keyes, Howard Phillips, Dr. James Dobson, and a whole host of other speakers were there. Jerry Falwell spoke. He was still alive. And that was during the first big battle where Judge Moore fought for the Ten Commandments displaying the acknowledgement of God behind our wall. And he was removed from office, and then he ran again for governor, and didn't win that, but then he ran again for Chief Justice, and he won that. Again, he got elected as Chief Justice twice. In the interim, he had Ben working for him at the Foundation for Moral Law. Ben was originally from New York, came down to Alabama and worked for the chief the first time. He ended up working with him at the Foundation for Moral Law. They worked on several cases. Here in Georgia, for example, they worked on the Ten Commandments case that in Barrow County that Congressman Jody Hice was involved in. It's actually the case that put Jody Hice on the map. Jody Hice was a pastor, and he got involved in that, and then next thing you know, he's running for Congress. He's been our congressman for the last 10 years in the 10th District. Ben's also worked on many other cases related to other things besides religious freedom, abortion, a lot of other types of cases that I'm sure he'll describe as he comes up here. But he's an attorney, but he's also a chief of staff for the state of Alabama Supreme Court, which, if you know anything about Alabama, the Chief Justice of the state Supreme Court is like the executive branch of the judicial branch. So they not only are dealing with cases and research and all of that sort of thing, but they're also the administrators for the judicial branch and all the personnel in the buildings and things like that, as I understand it. I'm highly honored to have him and his wife, who came all the way from Alabama to be here. They also have an excellent team. One of them was actually a groomsman at my wedding. Jose Horniman's one of his top researchers, and just one of the best judicial teams you'll ever meet in the entire country. Let's give it up for Ben DuPré.
Thank you so much. Appreciate the warm welcome. Glad to get through Atlanta traffic to be here on time. You all live here, so you know Atlanta is an hour from Atlanta, isn't it? Anywhere you are. So the topic of my talk is life, liberty, and pistols. Best Supreme Court term ever, and I hope to answer that one with a resounding yes. It's not often I can look back at a whole court term and just say, wow, thank you, God. And thank you, Supreme Court, both. So I'm delighted to be here with my wife, Jerusha. This is not our first time in Marietta, Georgia. In fact, we were here Saturday. My wife's like, great, you put that picture up, because we were at Whitewater all day. Our kids had never been, so what better time than just a few days before we got to come back anyway. So there we are at a quiet little hole in the wall. Yeah, right. That place is loud but hopping, and I have no idea how. But our crew, that's our 7 children that the Lord has blessed us with, and that I claim to the IRS. And oh, you better believe it. And somehow, you all live here, so you know what a miracle this is. I don't know if my wife had a $100 bill in her palm, but she ran in, and I said, just go see what the wait is, because it's Saturday night. Yeah, right. Like we're going to get in this place. We got seated immediately. That crew. So I don't know what happened, but we walked past about 40 people that were waiting, and I just kind of did one of those things. Hey, how are you? And we sat down, had a great, fun, loud time, tons of food that fed us twice over. So now I know why that place is so popular. What a great spot. I do want to note that I did come across the state line, and as you all know, on the border, we love to brag whoever the governor is. And I noticed something missing from your sign. Apparently Stacey Abrams is still not your governor, and I'm really glad to hear that. There she is at the... Yeah, we're all as glad as she is, and her supporters are as glad as those kids are to be in masks while she's not. So here's to still not your governor, Stacey Abrams. May she ever stay that way. But we have a bit of a trade going on, because last weekend, Friday night, Herschel Walker came and spoke in Montgomery. And we had Christy Nome. Yeah. So I feel like we're doing a little Georgia-Alabama swapping right now, although I am a poor substitute for Herschel. We had also Kristi Noem of South Dakota, and we had the the Attorney General from Mississippi who prosecuted the case that led to the Dobbs opinion. So she's a pro-life hero of mine automatically, right? And I'm going to talk about that case. That's the primary case I want to talk about, and you're probably familiar with a lot of it. I'm going to kind of deep dive. So we're going to do a little constitutional law review today. Boy, doesn't that sound exciting. I see some of you already rubbing your eyes. However, my love language is memes and sarcasm. So throughout my PowerPoint, keep an eye out for some fun things that you've probably already been texting your fellow GOPers here. Nathaniel was kind enough to mention I cut my teeth. The first federal case I ever appeared in was in Barrow County, the Ten Commandments display. Any of you remember that in Winder? They put up the Ten Commandments monument, and part of it was because of my then boss, Chief Justice Roy Moore, and his stance that inspired a lot of other people. It's how I met Jody Heiss, Mike Griffin, and a bunch of others, movers and shakers that started Ten Commandments Georgia. I remember going to, I think, a far-flung county. I was going to say Fulton County. That didn't make sense. You guys have like twice as many counties as Alabama, so it's a little hard for me to keep up. Our counties are huge. Yours are tiny, so you have a lot. So I remember going and advocating in another small county for a Ten Commandments display that thankfully they ended up putting up. So it was that fun season that I ended up in Gainesville at a federal court, and I remember the federal court judge being rather cranky and admitting, as federal judges can do because they're unaccountable, to the fact that he'd rather be fishing. And I thought, yeah, I guess if you're going to say that, I'd rather you be fishing than sitting on this case. But be that as it may, I did not say that as a green lawyer then. One more case that I have to mention because it involved Cobb County. Way back in about 2004, 2005, I don't think Nathaniel knows about this, when I was working with Judge Moore at the Foundation for Moral Law, you all here in the Cobb County school system had a sticker in your science textbooks. Anybody know where I'm going with this? Anybody know what that sticker said? Evolution is a theory, not a fact, and should be critically considered. Is anybody offended by that sticker that I just read to you? No, but Jeffrey Selman was, because his kid had to read that sticker in the front of his science book. So he filed a federal lawsuit against the Cobb County School District claiming it was unconstitutional. It's a violation of the Establishment Clause for his child to have to read that sticker. So we said, no, it's not. So we filed an amicus brief in that case. We weren't part of the case. We filed a brief saying, here's what the Constitution says in the First Amendment. Here's what it means. An establishment of religion has a specific meaning. It's a taxpayer-funded, government-supported denomination, usually of Christianity. And, there are certain perks you get if you're in that special church. That's what an establishment of religion is. A sticker in front of a textbook can never be an establishment of religion no matter what it says, and all this says is evolution is a theory, not a fact, and should be critically considered. Well, we all know that the left doesn't like to be critically considered, and so that went up to the 11th Circuit, and they actually kicked it back and made them do more factual findings. It was kind of a mess. Anyway, so that was another case that one of the first amicus briefs we filed in federal court was that case, Selman versus Cobb County, Georgia. So it's good to kind of come here and see how you all are doing. It's been a while since I've been here because, like I said, it was Saturday. So let's move on from that phase and move on from that phase. So is this the greatest Supreme Court term ever? I think so, and let's go to our good friends, the ACLU, for their take on it. They called it a radical Supreme Court term in review. I think their definition is a little different from mine, and they called it the most, see the blue underline there, the most conservative in a century. So I'll take that one. I take that as high praise. Let's see what our enemies are saying about it. They didn't like it. So it really was good. And it was good for several reasons. One, we didn't yet have our new justice on the court, who is not a biologist. Right. Justice Jackson, who's told us she's not a biologist. The left's had a rough summer, guys, and I think you need to be praying for them. We always do. They've had a tough conundrum to deal with because, one, we had the Dobbs opinion, and so now, no woman has rights anymore. And yet at the same time, if you ask them, who would those people be that you're referring to, women, then they're also caught because they can't define them unless apparently they're a biologist. So, they're really kind of stuck there, and let's throw them a shovel because they dug their own pit here, haven't they? And they just need to make up their minds. Which is it? Are we taking rights away from women? Are we supposed to believe all women like during the Kavanaugh thing, or can we just at least agree what a woman is? But really, what made this term so great, right? Who sits around ranking Supreme Court terms? Well, constitutional law nerds like me do this. And here's why it made it so great. It was so American. Are we allowed to say that? Are we allowed to say that we have an American form of government? And this is what I mean. We hold these truths to be self-evident, that all men are created equal. And you have to know what a man is, I guess, to define that. That they are endowed by their Creator with certain what? Unalienable rights. That among these are life, liberty, and the pursuit of happiness. Or to quote our president, you know the thing. So I say that because we have a very specific American form of government. Our rights come from our Creator, are given to us equally, and then we distribute those powers written in the Constitution of our national government or of our states, and we all have them, and they all acknowledge God. And we give them certain consented to powers, limited, and we reserve the rights to ourselves. Did I get that right? Pretty basic. It's almost like it's written in the Declaration of Independence that way. And it's almost like those that wrote the Declaration then wrote the Constitution. That is not impossible to interpret. And we're going to look at that. And what made these cases so great... I love that picture. There's so many good pictures in him. What made these cases so great isn't just the outcome. I'm going to explain what I mean in a minute. So we got three big cases that I'm going to highlight. There were more. There were some that restricted the EPA, for instance. There were others dealing with money going to religious schools in Maine. I commend those cases to you, but here's the kind of top three, because I know you don't want to be here all night. Dobbs, Kennedy, and New York State Rifle and Pistol Association. So we got life protected. We got in Dobbs. We got religious liberty protected in the Coach Joe Kennedy case, and then we've got bearing arms protected in my home state of New York. And let me just pause here, because you're like, why is this New Yorker talking to us? Okay, look, I on the day of my birth, I thought it was important to be close to my mother. So I can't help where I was born, but I did come south as quickly as I could. I went to Regent University in Virginia for law school, and then came down to Montgomery, where I met my wife, and Chief Justice Roy Moore, and so I feel much more at home here. Here's the fun thing, though. We were visiting my parents in Western New York, who are still up there in the People's Republic of New York. We got our passport stamped. And we were up there, and they're Christians, conservatives. There are many of those in New York, believe it or not. When the Dobbs opinion was released and when the New York State pistol law case was released, and the contrast between how the government officials up there reacted versus how the government officials in Alabama reacted just reminded me why I've been in Alabama for so long and why I'm staying. Because up there, New York was just screeching that there's guns flooding the streets. Now, I've become enough of a Southerner that I got excited when I heard that and looked outside, but sure enough, I didn't see any free guns roaming the streets of my small hometown of Brockport, New York. So I was disappointed. And then the Dobbs opinion, of course, it was the end of all rights. It was the end of women, that kind of stuff up there. Where Governor Hochul, who took over for Andrew Cuomo. If you can get worse than Andrew Cuomo, well, New York did it. They managed to find it, So that's their choice now, is between those two. So that's where I was when it came down, and it was an exciting time. And then, meanwhile, back in Alabama, because we're up in New York, back in Alabama, our Attorney General moves immediately to shut down every abortion clinic in the state, goes to Judge Myron Thompson, a super liberal, amen to that, a super liberal judge who struck down the Ten Commandments monument and said, remove your injunction on our pro-life law, and he did that afternoon. So by the afternoon of the Dobbs opinion being released on June 24th, every abortion clinic in Alabama was shut down. Look. So beat that, Georgia. It took you guys a few weeks to get caught up on that one. But I know I'm here with friends, and it's good to be here. So we got life, liberty, and bearing arms, the Second Amendment protected, and let's go through those one at a time. And they're three big cases. I say, greatest term ever, not just because of the correct outcomes, which we liked, protecting life, protecting religious liberty, and protecting the right to keep and bear arms outside of your home, but because the court went with originalism and original intent, the text of the Constitution. They did it the right way. Folks, I've been arguing for this stuff my whole life, and the court has rarely done it the right way. They've often tried to finagle it with their previous decisions and do all these gymnastics and try to cobble together some majority that includes, Kennedy or Chief Justice Roberts. But guess what? We've got the numbers now. We have enough conservatives on the court, actual conservatives, not the Chief Justice Robert conservatives, actual conservatives, that they don't have to do that. And so we're going to see in the Dobbs opinion, Chief Justice Roberts' position, he was completely isolated. And we had a strong majority to do what they wanted and to go by the actual words of the Constitution that we the people ratified. So it's so refreshing. If you've studied the Supreme Court cases long enough, you know that we crazy right-wingers will look at an opinion and go, yeah, they did the right thing, but look what they said to get there. And so they did it right, and they did it the right way. I mean, it doesn't get any better than this. Wow. The court applied the constitutional text, pull it out for dramatic effect, the text of the Constitution. It's not that hard. You guys probably have a pocket-sized edition of the Constitution. If this one looks thick, it is. It's got 3 more documents in it. That's how thin and small our federal Constitution is. Yeah. It's not big, it's not bulky, and it's certainly not alive. But it is still active. So according to what? According to the founders' understanding, not according to my understanding, not according to New York Times understanding or Harvard Law, God help us, but supported by history too. And what was the practice of the time of the states and of the federal government in and around that time that the amendment to the Constitution was passed? So they did the right thing plus the right way. Doesn't get any better than that. I could sit down right here and we could just be happy. But I want to talk a little longer. Dobbs versus Jackson Women's Health Organization. I have been outside the one remaining, now closed, abortion clinic in Jackson. It's painted pink. They've got militant women out there. I think they're women. I didn't ask them. We did not have a biologist on hand. And their shirts screamed everything that goes against what women generally stand for, which is nurturing and life. That's in Jackson, Mississippi. It was their one remaining, they had signs, this clinic remains open, and I'm glad to say they were wrong. 1973, Roe versus Wade. A little age check here. How many remember that opinion being handed down? I didn't ask you your age, I just asked if you remember that opinion being handed down. How many of you were born after January 1973? And I'm not going to check your IDs. Okay. Those of us that just raised our hands, we're survivors of a Holocaust.
That's right.
We are survivors of the American abortion Holocaust. That is not an exaggeration. Okay, I could have been killed in the womb. Many of my classmates were. Probably would have had 25% larger classes growing up. Maybe my church too, had Roe versus Wade not been in effect. Except for the fact that New York had already liberalized its abortion law before Roe versus Wade. I think it was New York and Colorado were already trending in that direction before the court said, let's make it nationwide. 1973, of course, the court held in Roe versus Wade that abortion is a constitutional right. If you ask them where it was found, they gave you, could be the 9th Amendment, might be this amendment. Literally, that's what they said. Then in 1992, there was a big push. A lot of people thought finally they're going to overturn Roe versus Wade. If you remember that, Planned Parenthood versus Casey, they reaffirmed it. They said, even if Roe is wrong, we don't want to overturn it because people might lose faith in us. How'd that work for them? This is my license plate tag, and I'm happy to say it is now expired. Not legally, just the word no Roe has now been fulfilled. So I got to come up with a new one, and that's the best problem I've ever had on the back of a car. So I've been driving that around Alabama for 20 years, and I had a couple of texts on the day Dobbs was issued saying, what's your tag going to say now? I said, I'm glad to have that problem. But I'll be honest, I didn't think I'd ever get to update it. I didn't think I'd ever get to the point where Roe versus Wade was overturned. I mean, let's be honest. Did any of you have enough faith in the federal government, in the U.S. Supreme Court to do the right thing?
No.
I did not. My faith was weak. Let's put it that way. Or perhaps properly, it wasn't in the court. So I have to say, but God. But God, that is now defunct or fulfilled. No Roe anymore. And there were a lot of people in that camp. Why do I say I didn't have a lot of faith? I'm sorry if that's hard to read. The top there says prior bad acts. Anybody recognize that gentleman? Dred Scott. He was a slave who had been brought into a free state and then returned back to his state, and he sued and said, I was free, I'm a free man, and you need to recognize me as such. Dred Scott versus Sanford in 1857 went all the way up to the U.S. Supreme Court. And in an infamous opinion, Chief Justice Taney wrote that he was not a person and not a citizen under the Constitution. It was a terrible opinion, and guess what? It was never overturned. Did you know that? Dred Scott was never overruled by the Supreme Court. We had the late unpleasantry, the Civil War, and then some amendments that took care of it, but it was never the court that said, oh, we goofed up. Sorry about that. We're going to overturn it. The court rarely does that, and I hope you understand that. That doesn't happen often. But it's not totally without precedent. They do it from time to time. So I thought, well, they never overturned Dred Scott. And then one of my also least favorite cases, again, I apologize for the background here. This is the Buck v. Bell case. On the left is a young lady named Carrie Buck. The state had declared her mentally insane and had her in an institution. She got pregnant. The state didn't like that, and they forcibly sterilized her against her will. She sued the state of Virginia that had, like a lot of other states at the time, that had bought into the eugenics movement, which is this idea that certain races and certain mental capabilities are inferior and therefore lesser persons, and we can sterilize them because we don't want them to reproduce. Horrible, horrible stuff. She sued the state of Virginia saying, I have the right to what makes me a woman. And the state said no, and it went up to the U.S. Supreme Court, and in another infamous opinion, the Buck v. Bell, the court upheld the Virginia law of forced sterilization, and it wasn't the only state. And the much celebrated by other people, Chief Justice Oliver Wendell Holmes said 3 generations of imbeciles is enough. That quote is in that opinion. 3 generations of imbeciles is enough to justify them upholding Virginia's law. The court, to this day, has never overturned Buck v. Bell. You might call it good law, but I don't use that term for Supreme Court opinions, and we'll touch on that later. So there's Buck v. Bell. We just talked about Dred Scott v. Stanford. 2 big reasons why I did not have faith that the Supreme Court would, fix what had started. But the Dobbs opinion is a breath of fresh air. It goes back to the Constitution. It said, the Constitution, here's a quote from the opinion written by Justice Alito. Now, many of us got an advance copy, didn't we, of this opinion, and I'm happy to report, I was real curious to see, because I work on a court. Number 1, if an opinion is leaked, heads roll. That does not happen, and it does not happen accidentally. So I'm real curious to see if they ever actually find the person that did it, because their career is done. Done. Yeah, some people think a justice did it. I don't know if it was Roberts. It could have been another one that's fond of her mask. But that's all speculation. I have no idea. I have a hard time thinking that a staff member, that a law clerk would do something like that, because it truly would be the end of your legal career, unless your legal career is legal activism and you're trying to threaten and intimidate the justices. So maybe they succeeded. But here's what I was going to say. The Dobbs opinion was virtually unchanged from the first draft that you saw. The only additions were responses to the dissenting opinion of the left. So the court held the line. They didn't water it down, even knowing they were being physically threatened and attacked, like Justice Kavanaugh at his house. They did not back off. They didn't blink. It's quite impressive. Here's what they said and what makes it so amazing. The Constitution makes no reference to abortion, and no such right is implicitly protected by any constitutional provision. It's pretty simple. They went on to say, even beyond the text of the Constitution, quote, a right to abortion is not deeply rooted in the nation's history and traditions. Here's where you can find it in the Constitution, the right to abortion. I asked our new Justice Barrett to show us. I still love that picture. For those of you who don't know, this was during her confirmation hearings, and Senator asked her, are you using any notes? Can you show us your notes? And she pulled up a blank pad that says the United States Senate had been put there for her. She had no notes. She's a legend, and I look forward to many more good opinions from her. More from the Dobbs opinion. Roe was egregiously wrong from the start. Who says I was not only wrong, I was wrong from the beginning? Its reasoning was exceptionally weak, and the decision has had damaging consequences. And tens of millions of children would agree with that. It is time to heed the Constitution and return the issue of abortion to the people's elected representatives. It's so simple, isn't it? It's so straightforward. They pulled out their copy of the Constitution. They said there's no abortion even mentioned in here. End of story. You can't imply it from any part of the Constitution whatsoever. And it's never been a part of our history and tradition. And the funny thing is, the court in Roe and in Casey said, well, we're just trying to settle this national debate. Again, how's that working for you? Did they settle anything? Did the pro-lifers go, oh, well, the Supreme Court ruled, I guess we'll just stop fighting for life? No, every child is still worth fighting for, and still will be in the days to come. Because I guarantee you, Georgians may not be getting abortions here, but they're going elsewhere for them. Or, with the help of our current president, getting abortion pills mailed to them. So the work continues. And the good work of people like Georgia Right to Life, where Abigail works, have plenty to do still. Plenty to do. Plenty of babies that still need to be saved, thanks to other states. But I'm thankful that the Supreme Court has got itself out of the way and gotten this fake right to abortion out of the way, so we, the people, can, through our representatives, affect pro-life laws. We do not pretend to know. Now, this is kind of funny because the opinion leaked and they got a whole lot of blowback. But they said, we do not pretend to know how our political system or society will respond to today's decision overruling Roe and Casey. But listen to what they said. And even if we could foresee what will happen, we would have no authority to let that knowledge influence our decision. In other words, we've got to do the right thing. It doesn't matter what the political blowback is. We can only do our job, which is to interpret the law, apply longstanding principles of stare decisis, and decide this case accordingly. I mean, this is a master class in how to apply the Constitution, or rather, what's not in the Constitution, and unfind rights that have been found. We therefore hold, they concluded, that the Constitution does not confer a right to abortion. Roe and Casey must be overruled, and the authority to regulate abortion must be returned to the people and their elected representatives. Hallelujah. Justice Thomas, who's the best. A Georgia son, yes? You know that. He's from here. Well, not from Marietta.
Camden County.
That's right. On the other side of the tracks. He wrote specially that he agreed with the opinion, of course, but he went farther. He said, now we need to go address all these other made-up rights that this court has come up with. The right to sodomy, the right to same-sex marriage, even the right to contraception. There's none of that in the Constitution. And so those are all under the umbrella of what's called substantive due process, and taking the word liberty and running wild with it to licentiousness. So, Justice Thomas, as usual, is dead on. There were some people that said, ooh, I wish you wouldn't have said it. I'm glad he said it. I'm not bashful. You may have picked that up. Here's what he went on to say, Justice Thomas, that 50 years have passed since Roe, an abortion advocate, still cannot coherently articulate the right or rights at stake proves the obvious. The right to abortion is ultimately a policy goal in desperate search of a constitutional justification. That's what it is. It's what they wanted, so they read it into the Constitution and prevented all the states from really stopping it. It's a terrible way to do constitutional law, and it's been deadly, literally. Now today, the court rightly overrules Roe and Casey, two of this court's most notoriously incorrect substantive due process decisions, after more than 63 million abortions have been performed. Now, your eyes kind of glaze over at a number like that. I called it a Holocaust. Anybody know about how many were killed by the Nazis? How many? 6 million Jews, but there were more. So yeah, probably 10, 11 million. We're not really fully sure. There were a lot more than just the Jews, but primarily it was a Holocaust for the Jewish people. That's just in our country. And I would say that that's a low number. Do you know California doesn't report how many abortions it does? Wow. Anybody want to take a guess how many abortions happen probably just in one county in California? It's horrible to think about. So that number doesn't even include California through the years. And it certainly doesn't include all of the undercover, under the table, that still happen, by the way, happened more since Roe than before. Dangerous, etc., unsafe abortions. Of course, all abortions are unsafe, aren't they? So I think that number is a lot higher, and I say that with dread. Chief Justice Roberts, I mentioned him. Did he hold the line here? Did he side with the conservatives? No. He said the court went too far. In overruling Roe, he said he would have upheld Mississippi's abortion ban, which cut it off it started at 15 weeks along. They have since, by the way, passed another bill to lower that age, basically, I think from, if I'm correct, from conception, with some exceptions. Like I said, there's still work to do. But he would not, Chief Justice Roberts said he would not have overruled Roe and Casey, nor would he have eliminated the right to abortion. This, thankfully, nobody joined him. He was all by himself, which shows you how much the court has changed. The guy that used to form the consensus and somehow find Obamacare to be a tax is now on his own, and not a single other justice joined him, not on the left or the right. And I'm thankful that if he's got to be there, at least he's going to be isolated when he pulls stuff like this. Now, the dissent in Dobbs, they were having a rough day. Catastrophic, they screeched. And the end of women's equality, autonomy, and any control a woman has over her body and life decisions. They did not define what a woman is. Don't ask. So women, I don't know if you knew that that's what happened on the day Dobbs was issued, but, newsflash. Here's their parade of horribles from the dissent. States will feel free to enact all manner of restrictions. It's almost like that's the Constitution. The Mississippi law at issue here bars abortions after the 15th week of pregnancy. I think they started clutching their pearls right about here. Under the majority's ruling, though, another state's law could do so after 10 weeks, or 5, or 3, or 1, or again from the moment of fertilization. And I would ask, fertilization of what? The dissent considered most threatening of all the notion that now, quote, the federal government may prohibit abortions nationwide. Once again, from the moment of conception and without exceptions for rape or incest. Amen and amen. Lord, let it be. I don't expect that from our current federal government, but hey, let's hear it for the elections coming up soon, right? So that was the dissenting opinion in Dobbs. They didn't like it, and it was a great day. What can I say? So I hope some people are paying attention to the blueprint that the dissent laid out, because again, there's more work to do. What's the impact of Dobbs? I mean, this is literally changing by the week right now. So I remember 2 weeks ago a meeting with our crisis pregnancy center in town, and they said people are going over to Georgia to get abortions now, and then they were going down to Pensacola. So we were trying to figure out, okay, how can we help these women? Where are they going if they're trying to get abortions out of state? Because that's where now they're going. What's been the impact of Dobbs just in a few weeks? It's been literally life-saving. Literally life-saving. We have, I don't remember, maybe about 5,000 abortions in the state of Alabama a year, and none are now going on, at least none that can be tracked. So abortion can now be made illegal, yes, from the moment of fertilization, and yes, without restrictions. It's now up to us to get our representatives to do that, to have the courage. You know what it means? It means pro-life politicians now have to actually be pro-life. Yes. They don't just run on a pro-life label. That's right. Because it's real easy to say you're pro-life and then go, but Roe versus Wade ties my hands. Because that's what a lot of them would do, and they would pass these meaningless pro-life bills, and then get a photo op and say, I'm pro-life. Really, what impact did that law have? It doesn't matter, I'm pro-life. I passed a pro-life law. Well, they don't have that excuse of Roe versus Wade anymore. So let's see them actually be pro-life. Let's protect all children from the moment of conception, regardless of how they were conceived. That's what the work ahead of us looks like. And how about a nationwide amendment, too? That would solve a lot of problems. That would save a lot of babies. Because unfortunately, it's not available in all states. My home state, I mentioned I was in New York. Their reaction was, we'll help women from other states come to New York and get abortions. For up to $4,000. They're just throwing money they don't have after abortion tourism. So as of yesterday, this is kind of what the map looked like according to the New York Times. So big grain of salt. Those are the states right now. It's obviously a heavy concentration in the southeast. Roll Tide. Where, that was for my Alabama fan over there. I know where I'm at, sorry. We're coming for you. That's where it's banned fully in the dark red, or at 6 weeks, some are showing, or 15, 18, or 20 weeks. So again, it doesn't look uniform. It's not a total ban in all states. It's still a minority. But it's changing rapidly. These are states that have a ban blocked or one in the works in the legislature, and I expect over the next several months, state legislatures will start cranking up. Ours is a part-time legislature, so we have to wait till January if we want to plug any holes in our law. And they're still very legal here. And I'm talking legal all 9 months for any reason, paid by the state in some of those states, New York, California, the left coast, right? They love their abortions. It's horrible. And now they're going to be drawing people from our states to them for that purpose. And do you think they're going to give them lots of love and care? No. They're going to take their money, maybe throw some tax dollars at them, throw them a couple of pills, go home, and have a horrible miscarriage in the privacy of your own home. Keep that away from us. Let's go to the Kennedy case. So I thank the Lord for the Dobbs opinion and the impact that it has and will have in life. Here's the Coach Joe Kennedy case. Maybe you're familiar with it. He's been on Fox News a lot, so he's now got a goatee and his hair's about as white as mine. And that's a picture of him taking a knee at the 50-yard line, and a lot of his players would gather around him. Okay, now keep in mind that the coach actually let go of a lot of the things that he was doing. He was giving them pep talks and leading them in prayer before the games. And the district said, please don't do that. And so he laid that aside. And basically they backed him down to the only thing he had left was after the game, when everybody was busy, he would go by himself and kneel and say a prayer on the 50-yard line. So we're not talking about a guy that was like trying to preach the gospel, in the public school classroom and leading them in Bible study. It wasn't like a humongous win for religious liberty in my view, but we're going to look at what the court did and see why it was a significant win. So this is what he was doing. Either the students would join him or they wouldn't. Sometimes it was the opposing team that would come and join him. And the reason the school district found out about this is kind of humorous. How do these things usually happen? Somebody what? Complains, right? The district found out because an opposing coach emailed the district and said, hey, I think it's really great what that coach does by praying with the students. We really appreciate that. And the district said, what? He does what? And so then they pounced after they were thanked for it. Wow. Anyway, so Kennedy, the Coach Kennedy case isn't as significant for the outcome, a coach kneeling by himself at the 50-yard line after the game, right? But it's how the court, again, went back to the text of the Constitution and how it meant according to the framers and the founders. So it was great what they did. Here's the First Amendment. You're all familiar with it. Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, or abridging the freedom of speech or of the press, or the right of the people peaceably to assemble, and to petition the government for a redress of grievances. So this case involved the first 5 lines. Establishment of religion, free exercise clause, and free speech. So it's going to get a little heavy here if you can follow along with me. Bremerton, that's the school district, fired Kennedy because it thought anything less could could lead somebody, a reasonable observer, to think that it endorsed his religious beliefs. So the school district said, we got to shut him down because someone's going to think we are endorsing this practice that he's doing. The court said that reasoning was misguided. Both the free exercise and free speech clauses of the First Amendment protect expressions like Mr. Kennedy's. Nor does a proper understanding of the amendment's Establishment Clause require the government to single out private religious speech for special disfavor. The Constitution and the best of our traditions counsel mutual respect and tolerance, not censorship and suppression for religious and non-religious views alike. It's good stuff. It's good stuff. But the court went further, and it pushed aside even farther some of its terrible made-up tests. The Lemon test, if you're familiar with that, and the endorsement test, which, not surprisingly, are almost always used to shut down expressions of Christian faith. They're designed that way. In place of Lemon and the endorsement test, this court has instructed that the Establishment Clause must be interpreted by, quote, reference to historical practices and understandings. There they are again. They're going back to, what does our history tell us? Prayer in schools? That lines up with our history. No big deal. You got a question?
Yeah, so I'm ignorant to this. What is the Lemon endorsement?
Okay, Lemon v. Kurtzman, I'm going to get to that. 1971, the court said, all right, something doesn't violate the Establishment Clause if it has these three things. You know, they just love to come up with these lists. Nowhere in the Constitution. Don't break out your Constitution. It's not in there. Has a secular purpose, a secular effect, and not an excessive entanglement with religion and the state. Is that clear? Don't worry, it's not clear to any judge that's ever applied it. So what they default to is shut it down. Shut down the religious expression. That's what every school district does. Religion, shut it down. We might get sued. And that happens all the time. I could give you many stories of me trying to plead with local officials. Don't shut this down. It's not unconstitutional. But we might get sued. And they're right. An analysis, second sentence there, an analysis focused on original meaning and history, this court has stressed, has long represented the rule rather than some exception within the court's Establishment Clause jurisprudence. Again, go back to the original meaning and history. I wish the court always did this. They don't. That's what makes this case so amazing. And they overturned the Ninth Circuit, which they do all the time, because it's in California, and the district court. Both of those courts held that what Coach Kennedy did was unconstitutional and that the district was right for shutting him down. So don't think that the Supreme Court, that, oh yeah, clearly they were going to go this way. It wasn't that clear because the Ninth Circuit, which by the way is overturned more than any other circuit, had held this way. And many other courts could have done the same. The Kennedy dissent just came out and said it. The court overrules Lemon v. Kurtzman today and calls into question decades of subsequent precedents that it deems offshoots of that decision. Again, I'm just applauding at stuff like this because Lemon has been a lemon.
Yeah.
So let's go to the New York State gun case. Yeah. Second Amendment. Who knew New York had a state rifle and pistol association? It was two guys. No, I don't know how many are in it, but there were two plaintiffs in this case. And you'll see why. They lived outside of the capital, which is Albany, which is an armpit, and they wanted a gun. They wanted a handgun, and the local official said, you can have one for hunting or target practice, but you can't carry it. Second Amendment says something different. A well-regulated militia being necessary to security of a free state, the right of the people to keep and bear arms, that's key, shall not be infringed. Again, pretty simple. A little convoluted in the grammar maybe, but the court unpacked that. And thankfully they did. In Heller and in the McDonald case. I'll let you read my meme right there for a second. By the way, there is a video out there showing these IRS agents training with dummy guns. It's hilarious. I am much less concerned now about the IRS police after watching that. In Heller, in 2008, the court did a deep dive into the history of the Second Amendment, and they held that it was unconstitutional for the District of Columbia to essentially prevent people from keeping a gun in their home. And that's what DC did. It was illegal, basically, to have a gun unless you had all these exceptions and it was taken apart and locked locked away. It was absurd. And then, so that applied to federal territories like the District of Columbia in 2010. 2 years later, they said, and it applies to the states. Two great opinions that went with the text of the Second Amendment and the history of our nation and said, of course, it means what it says, that we have the right to keep and bear arms individually. It was an individual right. The court recognized that the Second Amendment protects the right of an ordinary, law-abiding citizen to possess a handgun in the home for self-defense. That's all those cases dealt with, whether you could have a gun in the home. What made this Bruin case different is they said, we want to take the gun out, take it out on the town. But New York State had a law. Look how old this law is, 1913. Actually, it was 1911, and then they amended it in 1913, and it said that local officials could issue to a person a license to have and carry concealed a pistol or revolver only if that person proved good moral character and proper cause. Good moral character, needless to say, the New York governor probably didn't get one, and proper cause. What is proper cause? Oh, well, we lawyers love to give definitions. It's a special need. And you just have to convince your bureaucrat, your local town bureaucrat, that you have a special need for a gun. Live in a high crime neighborhood? Not good enough. Not special enough. Everybody does. Your neighbor got robbed? Not good enough. Have you been threatened or hurt or killed? It's a little bit too late, isn't it? This is the absurd law that over 100 years, look how old that law is, over 100 years, has been in place in New York. Thankfully, the court finally addressed it. They took a long march back through historical examples, not of the guns in the home, but okay, what have we done in American history of guns out of the home, people carrying open or concealed, okay? And they went through, they went back to the English common law and then all the way up through the 20th century. It was great. And they said that that New York, it was their burden, did not show any American tradition justifying the state's proper cause requirement for bearing arms. And New York's not the only one. There are about 5 or 6 other states that also have this. You got to have a proper cause. You got to show a special need just to get a gun permit and carry outside the home. And here's a couple of choice quotes. I'm not going to burden you too much. You guys have been very patient with me. The court said the constitutional right to bear arms in public for self-defense is not a second-class right, subject to an entirely different body of rules than the other Bill of Rights guarantees. McDonald, the case that applied the Second Amendment to the states, that was their citation there. We know of no other constitutional right that an individual may exercise only after demonstrating to government officers some special need. It's good stuff. It's great stuff. It's almost as if they're taking literally the right to keep and bear arms. That is not how the First Amendment works when it comes to unpopular speech or the free exercise of religion. It's not how the Sixth Amendment works when it comes to a defendant's right to confront the witnesses against him. And it is not how the Second Amendment works when it comes to public carry for self-defense. Good stuff again by the court. Again, when I was up in New York, it was hilarious to hear the howls from those government officials that wanted to have people come begging. What do these court opinions teach us? And then I'm going to wrap up. What do Dobbs, Kennedy, and Bruin tell us? What are some takeaways? I got a few. Number one, now hear me, let me explain this one. Constitutional law is simple. Constitutional law is simple. It's not necessarily easy, but it's simple. It's not super complicated. Nathaniel studied law. Any lawyers in the room? I'm about to out you. I thought you were smart, intelligent, normal people. I demonstrated to you how small our Constitution is. You can sit down and read it in an evening. It won't take you long. Don't try that with the Alabama State Constitution. It's much longer. It's over 1,000 amendments. Can I say, champions over there in Alabama. I mean, it's this thick. You have the words in front of you. There are no hidden words. It's not written in invisible ink. It does not change unless we amend it, and then we all know it changes. It's pretty fixed. It's pretty portable. And it's all there. And then what's not there is very plain as well. It's pretty simple. And the court in Dobbs kind of, again, went through a master class of how do we find out if it's in the Constitution? How do we know if something is a constitutional right? Is it in the text? Does the text say there's a right to abortion? Could it be implied somewhere? Is there a right to medical procedures if you're a woman? No, there's nothing like that even gets near abortion. So one, what does the text say or not say? And then two, is this thing you're claiming to be a right, abortion, sodomy, same-sex marriage, is it a part of our nation's history and traditions that are consistent with the concepts of what we say is ordered liberty? None of those things are. If you can't say yes to those things, then it's not a right. And it should not be considered a constitutional right or a fundamental right, as we sometimes refer to it as. So constitutional law is simple. You can do it. In fact, it was we the people that ratified the words of the Constitution. It was the farmers, it was the people in the market that debated about, well, should we ratify this? And what about this part? And they really wrestled with it. They understood it at the time. So we can go back. If there's words that might appear archaic to us, that's understandable. But you can go back and see what those words meant then. Not what Merriam-Webster updated its website 2 minutes ago to mean. Go see what the definition of a woman is if you don't believe me. So number one, constitutional law is simple, and we should all do it. Please, I beg you, do not leave constitutional law to the attorneys and the judges, okay? A lot of them are really smart. A lot of them get it right. But for many, many, many years, they got it really wrong with Roe versus Wade, didn't they? It's up to you, we the people, to hold on to our Constitution, to know it, to understand it, to study it. It's simple. It's not always easy, but it is simple. Number two, Supreme Court opinions are not supreme. They're not law, and they're not settled. Supreme Court opinions, the decisions issued by courts, are not supreme, law, or settled. What do I mean by that? Well, the Constitution itself says it's the supreme law of the land. It does not say court opinions. It does not say laws enacted by Congress, signed by the President, are the supreme law of the land. It says the Constitution is the supreme law of the land. And if anything contradicts it, it must give way. So, when you hear, and I correct our attorneys and clerks all the time because lawyers use the term case law. Case law says this, case law said that. I stop them, I say, it's not law. Don't call it case law. You can call it a case opinion, you can call it precedent, it's not law. Don't give it that level. Case decisions are literally opinions on the law. I mean, they're called opinions. I'm not, that's what they're called. They're not law.
Yeah.
But too often, lawyers and judges act like they are. And then finally, this idea that an opinion becomes settled law. This became the litmus test for every judicial appointee, right? Is Roe versus Wade settled law? Is it settled? Is it settled law? Is it super precedent? And the judicial nominee would hem and haw. Well, if we knew they wanted to say no, it was a terrible decision, they would say, I don't know that it's settled law, but I'll go with what the court says. They just kind of do this, this hat tip to Roe versus Wade for so long. We don't have to do that anymore. It was never settled law. It was wrong from the start, and that's what the court said. A wrong decision doesn't get settled because it gets old. I mean, this opinion was 50 years old, and the court reversed it. Here's the interesting thing. They referred to several other cases in Dobbs where the court has overturned itself. One time, the opinion was 3 years old. It was just a toddler. Another case, it was 100 years old. And the court was making the point, it doesn't matter how new or how old a Supreme Court opinion is. If it was wrong, it stays wrong.
Right.
Unlike you guys, it doesn't get better with age. See what I did there? Like a fine wine. So no opinion is settled law because it's not law and it's not settled. And it should be overturned if wrong, no matter how old. Number 3, we have not because we ask not. If I can quote the scriptures to you good people, we have not because we ask not. And for too long, we didn't ask. We didn't ask. one of the things I had fun doing at the Foundation for Moral Law is every brief we filed, we went back to the original meaning. And so every abortion case we filed in, we said, overturn Roe versus Wade, it's not law. Every Establishment Clause case we filed in, we said, this is what the Establishment Clause means, and this prayer here or this textbook sticker here is not an establishment of religion, and never will be. And finally, Mississippi took the ball, threw the Hail Mary, and got the home run. Got the home run. There you go. That was as useful as a football bat, as I recently heard somebody say that metaphor. So halfway measures on life, halfway measures on liberty get you maybe halfway, usually less. And that's for too long what the pro-life folks were settling for, is we're going to regulate around the edges and we just don't have a court. I heard that a billion times in my work. We don't have a court yet. We don't have the court yet. And now we have the court, and the court did the right thing. And this is key. Mississippi asked for Roe to be overturned. Chief Justice Roberts said they didn't have to. That was his point, is, well, and he complained about this. He said, well, when Mississippi filed its first brief with us, they didn't ask for Roe versus Wade to be overturned. They just said their law would fit under it, and we didn't have to overturn it, but we could uphold their law. And he said, that's what I thought they were going to argue. He complained that then when the court said, we will take the case, Mississippi said, all right, now that you're taking the case, you need to overturn Roe versus Wade. They did that. They did that. And guess what? The other side agreed with them that Roe and Casey were on the line. Like, Chief Justice Roberts asked both sides in oral argument, now can't we get along? Can't we keep Roe versus Wade and strike this case down, or keep the law in place here from Mississippi? And the pro-abort side said, no, it's all or nothing. So Chief Justice Roberts, again, the guy in the middle with nobody going with him, was trying to find the compromise that he was used to having. And not even the pro-aborts would go with it. Why? Because they know if they let one card out of the stack, the whole house of cards comes crashing down because it was all made up. So, and then lastly, I pointed out how old that New York gun law was, 109 years old. New York residents challenged it. They might think, man, that thing's ancient. I'm not going to get any traction trying to strike down this law. But they did. These two guys did, and they got it struck down, and now New York State is slightly freer. And I say that because a week later, you know what the legislature did? They passed a law that's even worse constitutionally than the law that got struck down. They require you to submit social media records and go through 60 hours, it's sub-absurd, maybe 16 hours of gun training. They're making it more difficult, so I look forward to that being struck down too. I'm going to end here with a couple more slides and then I'll be done. I'm going to go back to that Dred Scott case. I hate that case. I hate what it did. I hate what it said. But here's something to know. There was a really good dissent. There were actually two dissents in that case. I talked to a professor recently who makes his students read Dred Scott and this dissent. And he said, you wouldn't believe how many college kids come to me and said, I had to read Dred Scott like 4 times in college. I didn't even know there was a dissent. Because the colleges are trying to teach us to hate America. America's always been racist, and everybody has been racist and was for slavery. Have you ever looked at the history of the Republican Party? Anyway, so here was a great dissent in Dred Scott. Again, he's reacting to the Supreme Court saying that man, Dred Scott, was not a person, he wasn't a citizen under the Constitution. Here's what Justice Curtis said. When a strict interpretation of the Constitution, according to the fixed rules which govern the interpretation of laws, is abandoned. So if you abandon a strict interpretation of the Constitution, and instead you get the theoretical opinions of individuals allowed to control its meaning, okay, we have no longer a Constitution. That's what happens. When judges substitute their opinions and their policy goals and say, this is what the Constitution means, we've lost a Constitution. The words suddenly have no meaning. Then we're under a government of individual men. Not a rule of law, but a rule of men, who for the time being have the power to declare what the Constitution is according to their own views of what it ought to mean. That was Roe. That was Casey. That was many opinions we're still under the thumb for. Obergefell, same-sex marriage. Lawrence v. Texas, sodomy. So, But I also want to raise this assent to remind you that even when the court does terrible things, there's still a voice of hope and reason. And even if you're in the minority, be that voice of hope and reason, saying what the truth is, like Clarence Thomas does in every case. Always goes back to the first principles. Don't give up. Don't give up. It might take 109 years. It might take 50 years, like with Roe versus Wade, almost. James Madison, and I'll end here, the architect of the Constitution. Jimmy to his friends. President to us. I don't know if he was called Jimmy. Probably wasn't. Has this great quote in a letter he wrote. He says, "I entirely concur in the propriety of resorting to the sense in which the Constitution was accepted and ratified by the nation." He was there for it. In that sense alone, it is the legitimate Constitution. And if that be not the guide in expounding it, there can be no security for a consistent and stable, more than for a faithful exercise of its powers. He wrote this decades after the Constitution was ratified. I think it was 1824. And he says, you've got to go back to what the words meant when we ratified it. And we can do that. There are many, many documents, and you guys have probably studied those. And I encourage you to encourage other people. Don't give up. And don't forget that history of what those words meant. They had a meaning. They still have a meaning. And it's still good law today, this Constitution. May it ever be so. It has been such a privilege to share with you. God bless you, and God bless America. Thank you so much.
Can you hang on for a Q&A real quick?
Yeah. Thank you.
Thank you, Ben. Great job. Thanks for giving us that bird's eye view and even diving into some key points in those cases there. So we want to give an opportunity for some Q&A here, and I might start us off. I know when I was in law school, one of the frustrating things when I started constitutional law class was something you were alluding to. You know, you get so excited, like, I love the Constitution. I want to love studying the Constitution. It's going to be so much fun studying the Constitution. And then I started studying, and I realized this is not what the Constitution. I'm not studying the Constitution. I'm studying all these additional replacement tests.
How big was your constitutional law book?
It was like, yeah.
Constitutional law book is that big because it takes a lot of words for the court to get around the text of the Constitution.
Which is that big.
So you read all of the opinions in law school. It's terrible.
So you find out that there's all, we know that we have rights under the Bill of Rights, but the court has like a ranking system of which rights are more important than others. There's, like you said, fundamental rights, and then there's lesser rights, and they have a ranking system. And then they have classes of people. Some things that are subject to strict scrutiny, and other things that lesser scrutiny. And so it's interesting how they effectively replace the Constitution. When a justice does that, and you're a legislator or a president in office, and you're holding our judiciary accountable, it says in the Constitution they hold office when they are behaving themselves correctly. Do you think it's appropriate for us to impeach justices that stray that far from the Constitution, actually replace the text with their opinions?
Great question. Yes. And for too long, Congress would hide behind the robes of the justices. Well, the courts ruled. They ruled in Roe versus Wade. There's nothing we can do. Last I checked, every single branch takes an oath to the Constitution. Every single branch takes an oath to the Constitution, not to the court. And for too long, legislators, state and federal, have used the excuse, well, the Supreme Court ruled, and like Ewoks in Star Wars, we just have to bow down to them because they are the judicial gods. And so I think, we need to sprinkle in some impeachments if we can get legislators that have that will.
Now, one of the cases that you didn't get into because there's so much rich content to address, but you have the EPA case, which one of our big concerns right now is with the deep state.
Right.
And all this bureaucracy that we often are concerned actually is exercising more control in our federal government than the Congress does, or the president is able to. The president can't fire a lot of these people.
Right.
So they're in there for life, and they just hired 87,000 more IRS agents that are now added to that deep state. So what do you think the significance of the EPA case, pulling back some of the power of the bureaucracy? What do you think that will do to help us undermine the deep state?
Yeah, just a little about the EPA case. Basically, Congress passes a law, puts these things in motion, and then these agencies run with it, and they go wild. and nobody calls them to account. And the court basically pulled the reins in and said, no, the EPA can't have more authority than what the law says. And so it really, as it should, chained these executive agencies to the law that they're supposed to be upholding. That was an important case, right? Anytime we kind of pull the reins back on the wild federal government is a significant case. And so that was another one. I didn't go into that tonight, but that's another huge case that I hope, because the more the government is restrained, the more liberty the people have,
Right.
especially the federal government.
And then there was another big decision for school choice.
Right.
I mean, the Republican Party has been campaigning against a federal Department of Education. I saw Congressman Thomas Massey again introduce legislation with a co-sponsor to get rid of it. Ronald Reagan ran on that originally back in 1980. We haven't made a lot of progress there, but there is a growing concern about education. We had a lot of people here who are going to school board meetings. They're concerned about CRT in the schools and what value could be had if we're able to free up this monopoly that the state has over education.
Yeah, this was a case out of Maine where Maine is very sparsely populated. And so they have areas where the only school is a private Christian school or sectarian school, right? Not a public school. And so the people, there were state funds available, but the state was saying, well, no, we can't give you money to send your kids there because it's a religious school. Again, using that religion excuse. And so there was a lawsuit brought and it went up to the U.S. Supreme Court and they said, no, you can't discriminate against these schools because they're religious if they're participating on an even level with the other public schools. So again, it was a correction of using the Establishment Clause as a club against religious schools and religious expression and bringing it back to preventing that religious discrimination that we're seeing often in the name of the Establishment Clause.
Awesome. We got a question from Mr. Impton, and then another one.
Well, maybe a
Okay.
question, maybe a comment.
Yes, sir.
First, Ben, thank you for your presentation. It was certainly
My pleasure.
educational. We have the Constitution and the Bill of Rights. We know what our rights are, but we also have expectations. And we've got expectations in regards to our justice system. I'd like to talk about what went on in 2020 in the election that many of us in this room have had personal involvement in, personal observations of the voter fraud that has occurred in this state, and especially in this county. Not a single court in this state has been willing to accept a case to listen to the evidence. We have an expectation that the justice system would be willing to listen to the evidence. We have lost absolute confidence in our justice system in this state, perhaps in the country. I only want to talk about this state. You're aware of what's been going on. We're all aware through personal knowledge of this voter fraud. Massive evidence has been collected by a group, Voter GA, Garland Figueredo. We have seen that evidence. I'd like to ask for if it's possible for us to get help from you and from the Chief Justice of the Supreme Court of Alabama in order to empower a grand jury in Alabama, and if empowered, would have the authority to do whatever the hell it wants to investigate voter fraud anywhere in the country, including this state. Can we get your help and your Supreme Court or your Chief Justice or whoever can do this for us to get a grand jury empowered to enable us to present this evidence and have it listened to?
Thanks, Leroy. Thanks. I'm not sure how familiar you are with everything going on here.
Well, yeah,
Politics, and all that.
we've all been looking at Georgia. I don't have any remedy for you being where I'm at in a neighboring state. I mean, I don't. We could talk maybe off microphone, off recording about options. We don't impanel grand juries as the court. That's done by law enforcement. So that, I think, is where it needs to be. But I do believe we're not going to be able to count on the federal government, of course. But I think that's where you guys here have to just pressure your state representatives, your governor, and your law enforcement officers. I know you already have. I know you have. I just don't see what we next door can do here, because our jurisdiction is in Alabama.
Will you accept immigrants from the state of Georgia?
Come on. Absolutely.
We got some more questions. Paul, do you have a question?
Here, there's, next
Oh,
right
sorry,
here.
Lloyd's got it.
I have a quick and maybe simple question. In your knowledge or opinion, is Chief Justice Roberts compromised?
Maybe not just in his worldview, but in, yeah.
I have no inside knowledge of that. I do think his court opinions are compromised. They're compromising, but I don't know whether he is. I had my suspicions about another justice being the leaker, but it's all speculation. We don't know. I don't think they'll ever actually get to the bottom of it. I don't think they want to. I hope they do, and maybe Chief Justice Roberts wants to. I don't know. If they haven't found him by now, I don't think we'll find out. But I'd love to know who. Yes, sir.
Changing directions real quick. Will Judge Moore, which he deserves, get that $8 million?
Yeah, so Chief Justice Moore, my former boss, just won an $8+ million defamation lawsuit against a Democratic PAC that ran this horrible ad. Yeah. It's a huge win in federal court before a federal jury. I sure hope he gets all of it, but it'll be appealed, I'm sure, to the 11th Circuit here in Georgia. But I sure hope he does, because I had taken leave from Chief Justice Parker and was working with Chief Justice Moore during that campaign, and it was quite devastating to have all those lies immediately trumpeted. I'll tell you the funniest thing, not the funniest thing, but looking back, within an hour of the allegations coming out in the Washington Post, do you know who the loudest people were calling for him to step down? The Senate Republicans. Within an hour, before Judge Moore could even put out a response, they were calling on him. So if you follow the arc of his race, it's pretty clear who didn't want him up there in Washington.
Right.
Yes, sir. So I hope he gets $8 million from that group and a bunch from all the others.
Yeah, exactly. You know, we also want to give credit to credit's due. We're grateful that President Donald Trump appointed these 3 justices that have shifted the court like they did. If we look at the history of the last 40 years, Reagan that really ran on a platform of trying to change things. He got 2 great nominees in, but then we lost the Senate in 1986. So then the next 2 guys he appointed, Kennedy and huge disappointment from Kennedy. Actually, Senator O'Connor came before they lost in 1986. Yep. But if they had lost the Senate in 1986, do you think that some of these cases might have been overruled sooner? Some of these bad precedent might have been overruled sooner if we gotten Borg, or if we gotten Ginsburg, or somebody like that?
Yeah, I mean, hindsight's 20/20, right? And for some reason, these justices always slide to the left. So we have to start them off way on the right and hope they end up somewhere in the middle by the end of their term. I mean, that's now become kind of the arc of a Supreme Court justice's career. So, yeah, we're seeing the effects of having a president and having a Senate that can get the good judges through without having to play the games. You know, part of it, Sandra Day O'Connor, they wanted to win on getting the first woman, back when we knew what a woman was, on the U.S. Supreme Court. I mean, that was part of it, you know. And so elections have consequences, and they have consequences that now we're seeing in our Supreme Court opinions.
And we have a big Senate race coming up here in Georgia in just a couple months. And we're really close in the Senate. Getting back the Senate will not only help us get good judges in, it will help us prevent bad judges from getting in.
Boy, you guys have a couple of doozies for senators, I tell you.
Yes, I would like to know what steps could we take to make sure that any person that is running for any political office or working for the government must first pass a constitutional test.
So groups like, I would say, Georgia Right to Life and Susan B. Anthony, they should be sending out, surveys to candidates. And you ask those tough questions. Don't give them a lot of wiggle room. Get specific on your questions, and you can also quiz them. Give them a little civics quiz, right?
Pass a test.
Before. Right? That's why it's good to vote for immigrants, because we know they probably know more civics than the average American voter and politician. And I'm a legal immigrant, by the way, not an illegal immigrant. But seriously, if you've ever seen what they have to learn, it's what you all learned back in your civics classes and what they no longer teach. They don't want to teach this stuff. So I think you're absolutely right. If we continue to put people up that are just really good at sloganeering and have no idea what their role is and what the other branches are, they're not going to be impeaching anybody, and they're not going to be getting good laws in place. That'd be great.
You got a question, sir?
I do, Ben. Thanks. Great insight. Great presentation. Awesome. What's on the docket for the Supreme Court next term, and what are the big issues, and what, if anything, might be overturned or directions changed? Do you have any?
You mean the U.S. Supreme Court?
Yeah.
Right? Sorry, I work for a Supreme Court, so just clarify.
But same thing with Alabama. If
Yeah.
there's some stuff there that you think might impact nationwide or set some precedents, that would be interesting.
Yeah, usually we don't have the nationwide stuff, just the statewide stuff. I would expect, not in this next term, but in 2 terms, we'll see a flood of these new pro-life laws being challenged. But the challenge is, what do you argue now? You don't have a right to abortion. So I'll tell you where I see a future argument available, and that's this. Are we giving equal protection of the law to the unborn in a state where they can be killed, but it's illegal to kill a born person? Let me ask that again. In New York, it's illegal to kill a born person, but legal to kill an unborn person. Are we giving them equal protection of the laws as required by the 14th Amendment? I think that's an argument that can be made. And what will that do? That will make it a constitutional right to be alive in the womb. So we're flipping the right to abortion and saying, no, we have a right to life that should be protected nationwide. Now, that doesn't answer your question about what cases are on the docket. I don't
Just to
know.
review, the 14th Amendment specifically applies to the states, not just to the federal government like the 5th Amendment does. And it says no person should be deprived of life, liberty, and property without due process of law.
Right. Nor any person denied equal protection of the laws in a jurisdiction of a state. So if the murder laws protect you, it should protect you whether you're born or unborn. And I think that's an argument that's ripe now for the taking.
Right. Got another question here.
Thank you. I was raised that with the understanding that the job of a judge is to sit back there, take cases, judge cases, and that's what he or she gets paid for. So my question is, a lot of us have had a number of lawsuits filed on our behalf over the last few years. Now, I don't want to get into all that. We've kind of discussed it already. But we've had an overwhelming number of judges who have simply refused to hear the case. Mm-hmm. And if that's your job, to hear cases, how can they get away with that?
A judge in general has a duty to sit on the case unless he's disqualified. And he's disqualified if there's an ethical conflict. He was involved in the case, or he has information he knows, has knowledge about the facts underlying the case, or he's related to one of the parties, right? You wouldn't want a judge sitting on that. Right. But there are probably a lot of judges that just don't want to touch a case like that, and they'll recuse. And you can't really question them. Well, I don't know how the judicial ethics works here in Georgia. I'm very familiar with it in Alabama, having worked for Roy Moore twice. But you'd have to ask them for an explanation of why they got off the case, but you're not likely to get that. So what you need is courageous judges. Are they elected here in Georgia on a partisan ticket, or is it a nonpartisan?
Nonpartisan.
Nonpartisan. So we have a partisan ticket in Alabama. So you run as a Republican, you very rarely run as a Democrat these days for statewide office. But
And then the trick with that is that a lot of times our governors will appoint them before a term is over, so they already have the incumbency.
Right.
And then people just re-elect the guy with the
That's right.
incumbency next to his name.
Right.
And we were looking at the voter data. One of the justices that one of the Republican governors recently appointed actually voted Democrat in some of the recent elections. So just because he was appointed by a Republican doesn't actually mean necessarily that he has a Republican worldview.
yeah. Yeah, and a lot of judges, when they run, are allergic to making any real statements because they say, well, I'm going to be on the court, so I, vote for me, but I'm not going to really tell you what I stand for. And it's just a weird, it's just a weird dance that a lot of them do, and they think they have to do that because of their ethics rules, but they can say more than they probably do.
So I got a question next.
What does your hat say?
Oh, it says...
It's just a hat snowflake?
Yes. I try to wear as many red hats as I can.
That's fantastic.
So first, sort of a statement about Leroy's question, just to sort of elaborate on the frustration that a lot of people have. It's really a statement, not a question. People don't know where the buck stops about the election laws, the election lawsuits. Because every time we ask, the buck always moves somewhere else.
Right.
And right now it seems to all of us untrained novices that know really nothing about the law, the buck doesn't stop. Nobody answers the question. Like, the supreme law of the land didn't even touch it. Nobody is willing to even speak about it. Nobody in any of the three branches of government. So that's sort of the root of the frustration right now, in my opinion, about this. But I just want to comment about that. My real question has to do with the border. Recently I saw, I think it was on the Texas border, there was a sort of a conflict. The state National Guard was locking a fence on the border, and the Border Patrol just walked right by the National Guard and opened it up. And I know nothing about the law, so what was stopping those National Guardsmen from just arresting those federal agents on the spot?
Well, I mean,
something had to.
You mean you're not thankful that those Border Patrol agents were there to, handle the border matter? Yeah, it's absurd. I mean, it's backwardsville. I mean, they're doing the opposite of what they should be doing. They should have helped secure that border, but they're under orders. And that goes up that chain, and that's the president and the vice president, who hasn't been to Europe either. She hasn't been to the border. It's intentional. I love what Texas is doing by putting them on a bus and sending them to D.C. And now they're complaining that they have all these illegal immigrants in their city. But wait a minute, I thought you wanted that. So, yeah, Hosea's brother-in-law worked for our mutual friend works down in Laredo, Texas, on the border, and they basically have an agreement with the cartel that the cartel will stay on their side. They won't shoot at their officers. Because if they do, Border Patrol shuts it down and the cartel loses millions. So they just Laredo is kind of like a bubble of illegal immigrants, and they just kind of keep them in Laredo back and forth across the border. So there's so much dysfunction at the border, and it's intentional. So I say we just need to get some more buses. I think one of them, they tried to let off in Georgia, right?
Yeah, they
did let off in Georgia, and the sheriff showed up. So, it takes those local officials also being on the ball, and that sheriff showing up and going, no, get back on the bus, you can't leave him here. That's right.
That actually makes a good point. How come the sheriff had the authority to do that, but the National Guard didn't?
Yeah, well, I wonder what would, that's up to Governor Abbott. I mean, if he wants to get into a spitting match with the Border Patrol, I think he can. But I think he made his point by by locking it and then getting Border Patrol to go unlock it. We just need to keep letting the left and the Biden administration do what they're doing and do it out in the open and record it and put it out on social media. Just let the American people see what they're doing. That's opposite of their oath to defend this country and our borders and the Constitution. That's our best weapon right now is free exchange of ideas, free speech, and free media. Yeah, freedom of the press.
So, Ben, you're a very talented, gifted individual with convictions. You got a lot of knowledge under your belt, you got experience, worked for two extraordinary men and a lot of great battlefield skills. Any chance, I know Chief Justice Tom Parker's term is going to be up, I guess, next year, at the end of next year.
January of 25 is his last
Oh, I'm sorry.
month.
Okay.
So
25,
yeah,
okay.
about a year and a half.
So when that chapter of your life is over, is there any chance you might consider running for office, either legislature or in the judicial branch, in some way?
If you'll all come to Alabama, we can have that conversation. I'm not going to get any votes from you all here. Well, I don't know. Maybe I will. Hey, sounds like the votes are up for grab here in Georgia.
I
Sorry.
get some donors here too.
No, I'll be praying about what the Lord has for me next. Alabama needs some good judges. We've got some really good judges. We could use some more. But if the Lord tells me and my wife agrees, maybe we'll do something like that.
You could move to Georgia.
Hey,
You can also move to Georgia, he says.
that Marietta Diner was tasty. That's for sure. My mother-in-law is from Dalton, so my wife's mother.
Awesome. Well, hey, we really enjoyed your speech. Thank you so
Thank
much
you.
for coming out and speaking with us today.
Thank you, guys.